Hello everyone, and thank you for attending this webinar on everything you need to know about trademark protection north of the border. I'm one of your moderators, Hannah Samandinger. I'm a legal product manager at Alt Legal. We're also joined by Nahal Madani, who's the CEO at Alt Legal, and John Lee, who I'll introduce in just a moment. If you have any questions during the webinar, please feel free to use the chat feature on GoToMeeting, which will be on the right side of your screen. Although we may not answer your question immediately, we'll certainly circle back and enter it at the end in our designated questions section. I'm so excited that today we're joined by John Lee. John is a Canadian practitioner who just started his own solo practice. Prior to doing so, he worked at Denton's, a global law firm, and he also worked as the Assistant General Counsel at BlackBerry, where he helped develop their global anti-counterfeit program. John's been working in the IP space for about 20 years now, so he truly is an expert, and I don't think there's anyone better to speak on this topic today. I'll provide an overview of Canadian trademarks, sharing with you everything you need to know about getting protection abroad. Then Nahal will provide a brief demonstration of how Alt Legal supports Canadian trademark docketing. And lastly, we'll open it up for any questions you might have. As a brief introduction, so many of you may have heard that Canada is in the process of making some changes to their IP regime. This interim period while the changes are pending is a great time to help your clients seek any protection for their marks in Canada. Many American IP attorneys actually don't even think of taking this extra step in protecting a mark, but as you'll see during John's discussion, it's certainly a step worth considering. Here at Alt Legal, we're also working with the Canadian IP Office so that we'll be able to automate Canadian IP filings, which will make maintaining a Canadian IP portfolio even easier. We're going to keep the scope of the webinar to a practical overview for U.S. practitioners. Solo and small firm practitioners in particular can really benefit from understanding how these rights work in conjunction with the U.S. rights they're already seeking on behalf of their clients. So with that in mind, we'll just be focusing on giving you the practical knowledge that you'll need to obtain IP protection in Canada. So I'm going to pass the webinar off to John Lee, our guest, who will walk you through everything you need to know about seeking trademark protection in Canada. Thanks for joining us, John, and the floor is all yours.
Thank you very much, Hannah. I'm really pleased to be speaking to the group today. It's always exciting to talk about Canadian trademarks, which is an area very close to my heart. It's often good to know where everybody's coming from too, and if you want to type into the chat box where you're viewing from, it's always of interest to me to know where some of our audience is seated as well. So today we're going to be talking about Canadian trademark matters, and everybody knows where Canada is. Of course, some people describe it as America's hat, but of course, north of the 49th parallel, we've got a lot of land. More interesting, in preparation of this assignment, I looked at some statistics, and I was surprised to discover, and the statistics I located were for 2012, Canada did US 292 billion in imports from the US, and the United States imported $324 billion in goods from Canada. And from those of you may remember from your high school economics or history courses, Canada is the US's largest trading partner. And with our population in Canada huddled along the 49th parallel in cities like Vancouver, Toronto, Ottawa, Montreal, there's a huge market that's literally next door. And for Canadian consumers, my experience is that they don't really distinguish between the border when it comes to purchasing goods and services. We all want the same things, whether we're in Canada or the US. Of course, there's some cultural variations. Some of you may have heard about Target's attempted entry into the Canadian market, which didn't go so well. And for those of you who have been to Canada, know about our love for Tim Hortons coffee. That being said, the convergence of online shopping and competition among retailers for both offering goods and services in an integrated manner has made branding extremely important. And I'm not going to get into detail, but there's an interesting development in the news this week about Trader Joe's and Pirate Joe's. And there's a Canadian retailer in Vancouver who's been going across the border into Washington State and other cities for many years, buying Trader Joe products and then reselling them at his store named Pirate Joe's. And that's before the courts in Washington right now, I believe. And I think it crystallizes some of the unique challenges of trademarks being territorial and limited to region, whether it be at the local level, within a community or a state, if it's a common law mark, or if it's actually a nationally a registered trademark with national scope and its rights. How do we deal with cross-border issues? In the simplest cases, we look at registering in the territory as a whole. So that's my overview on the common market. And one of the big challenges, of course, is developing a reputation when you're not actually using a mark in a territory is a big challenge as well. And Trader Joe's, I think, has encountered some of the limitations of the making known issue, especially because there's no Trader Joe's stores in Canada at this time. They don't have use in Canada. So ultimately, you can still register your trademark in Canada right now without having used the mark, and I'll be explaining that later. And as Hannah alluded to, there's also going to be some changes in Canadian trademark law. The legislation, which I'll get into later, has been passed, but it's not yet in force. So ultimately, I'll share with you a quick story, and I've changed the trademark and some of the details in order to protect the privacy of my client. But I had, the facts are essentially the same. I had a client with a US restaurant called Simone's Meatball House, and they were registered in the US and offering their service in Dallas, Texas area. Coincidentally, a store or a restaurant in Toronto called Simone's Meatball House opened up and started offering business. Our client based in Texas learned of this through online and social media and was surprised to even see some of its glassware and other products in their social media pictures, suggesting that somehow they had definitely known about our client's activities and their business, and it was a classic case of copycat services. So what happens in this situation? And the first thing is, well, what's our client's rights in Canada? And to cut to the chase, I mean, the good news is they actually had registered their mark in Canada. And it was a huge relief to me, because if we had to go out and seek to enforce trademark rights from Dallas, Texas, in Toronto, Ontario, without a registration, the evidentiary burden would have been extremely high. We would have been looking at common law rights and was there any reputation? Would there be any confusion among consumers? And I'll speak plainly, chances are no. And so there wouldn't have been much our client could have done. However, even though they hadn't used their trademarks in Canada, or didn't even likely have a reputation in Canada because they weren't well known, the infringing party was quick to shut down after receiving a cease and desist letter that set out our client's registered trademark rights. And as a result, the U.S. counsel who helped them out with the matter looked quite good. And part of my goal today is to give you the information that you need in order to advise your clients and think about proactive steps that can be taken to protect their rights in Canada, given some of the market issues. So let's talk about trademarks. What I'm going to share with you today is probably not going to be new to those of you who are working in the trademark space, but I think it's always good to have an overview and see how some of the nuances are different on the local level. Of course, our Trademarks Act recognizes both business names and trade names when it comes to passing off and infringement issues. In Canada, as in the US, unregistered marks are called common law trademarks. We don't have the equivalent of state trademark registrations, though. They're only registered at the federal level. And again, as we do have a trademark registration system, we have carve-outs for unique types of trademarks, certification marks, which are common among those who provide collective standards to third parties. We have industrial designs, which is different from an ordinary distinguishing guise. A distinguishing guise being the shaping of the goods or services or its packaging. An industrial design is the Canadian equivalent of a US design patent. So if you're dealing with clients that have a unique shape to a product, and in the US they have a design patent, in Canada the equivalent would be an industrial design. If you've done it as a three-dimensional mark or the shaping of the product in the US, then we would have, it would be under the trademark in Canada under what's called the distinction guise. And the most unique thing about Canada, which I'm not aware of there being any equivalent in any other territory in the world, is this unique creature called an official mark. And when I was plotting this out, I actually wanted to maybe put a big dragon here or something, because they really are a bit of a beast. And official marks, I describe them as Uber marks for public authorities. And I was using this phrase long before the ride-sharing service started. Official marks relate to are rights granted to public authorities for the logo or the term without having any reference to goods or services. So typically when you're assessing confusion or descriptiveness, the trademark is always considered in association with a good or a service. Official marks just block out that term without reference to any goods or services. So in an ordinary case where you can have Apple Auto Glass coexisting with Apple computers, if the Ontario Lottery and Gaming Corporation has trademarked the term Apple, they have the right to prevent any trader from using that term who adopts it subsequently or uses it in trade, regardless of what the associated goods and services are. It's a unique feature, and it can trip up some traders. So when you are looking at expanding, or your clients are looking at expanding their brands into Canada, locate searches for identical marks are recommended. And if it's a official mark that turns up in your search, I recommend you talk to local counsel in order to get some advising on how to address it. And again, these are the other unique thing about this: the public authorities historically have been quite broad, and going back to 1990s and early 2000s, charities were getting these types of marks. Since then, they've tightened up the criteria, or they've become more strict in the application of the criteria, and it's limited to entities that are either under the direct or indirect control of a government agency. So a bridge authority, provincial lottery associations have them. Some public healthcare entities like hospitals, associations intended to deliver healthcare services on behalf of the government and so forth. There are others who get that type of public authority status as well. I've spent a bit of time on that, probably more than I intended, but it's the one, hopefully if you remember one or two things from this, remember about the unique nature of official marks in Canada and how they can be a wrinkle to address. The registration process in Canada is not much different from the US. We go through filing examination. In Canada, our trademark examiners are not attorneys as they are at the USPTO. They can have a legal background and a law degree, and many of them do, but for the classification of the role, it's not actually a legal position within the government or the Department of Justice as other entities, and that's at the USPTO where we have examining attorneys. That being said, they're well trained, and they have a policy division that establishes all the policies and procedures for the trademark examiners to follow. One other thing I'll mention is that we do not have a supplemental register in Canada. We only have a primary register. And I'll talk more about each of these sections, including oppositions, proceedings, allowance, and post-registration in the next few minutes. So moving ahead to filing, an application can be made with one or more claims, and presently you have to identify whether the application is in use in connection with some or all the goods or services, or the applicant intends to use it in connection with some or all the goods and services. The difference in Canada is that that claim has to be made accurately at the time of filing. As you may be aware, in the United States, you can file on the basis of use and convert to intent to use later, or convert from intent to use by filing a specimen throughout the application process. At this stage in Canada, when you file, you have to have the dates correct. You cannot amend the application to an earlier date of use. You cannot convert from intent to use. And you have to be accurate, because once the application is advertised, if the claims are incorrect, that could be a successful ground of opposition. The other basis that you can file an application for is making known. So if you haven't actually used it in Canada, but if you've got a company that's been near the border, that's been broadcasting television and radio ads for 20 years, and everybody across the border knows about it, and they can establish a reputation, it can be registered on the basis of making known. And the most interesting ground, and one that's common for our US clients, is use and registration abroad. And that means that you can get protection in Canada, you can have the mark registered here without having actually used it in Canada, without actually having an intent to use in Canada. And this would be a great basis for Trader Joe's, for example, to register its trademarks here on the basis and strength of its US trademark registration. Moving ahead to the other part, the key part of an application is goods and services descriptions. So typically, like the USPTO, our office requires the goods and services to be described in ordinary commercial terms. Historically, we've been kind of similar to the USPTO in the level of detail that's being required. In the last 2 to 3 years, owing to the ramp up for changes in our legislation, which I'll describe later, our examiners have become over particular in the description of ordinary commercial terms. And my experience is that they require even more detail than the USPTO does. And for those of you who've dealt with the PTO on goods and services descriptions, know how finicky they can be. Unfortunately, it's a little more painful in Canada. We do have a wares and service or goods and services manual that's online, and depending on whether it's a fresh application or something that's leveraging an existing US registration or application, some pre-planning can help avoid some of those issues. We currently don't have a class system, but we will be moving to one. The interim step is right now when applications are being filed, it's at the applicant's election to designate the goods and services to a class. There's no, the current fees, which I'll discuss later, are not class-based. It's a flat filing fee. When we transition to a mandatory class system, it'll be like the USPTO, where fees will be paid per class. When the examiner reviews the application, they'll be looking at 2 aspects. One is formalities, the second is entitlement. Formalities relates to whether or not the mark is inherently registrable, such as whether or not it's clearly descriptive or deceptively misdescriptive, whether it's prohibited, whether it's scandalous, and whether it's primarily merely the name or surname of an individual. Those types of issues are very similar to the type of review that the USPTO grants. The second is entitlement, which relates to whether or not it's confusing with any prior applications or registrations on the register. The test for confusion in substance or in essence is more or less the same as the US test, but it is articulated a bit differently. As a rule of thumb, and I can say just based on my experience, for US practitioners, the first intuition about whether marks are confusing or not using a US standard is probably the case in Canada 80 to 90% of the time. Once the application's passed the examination stage and all of the minor issues, if any, are dealt with, and there's no critical obstacles, it's advertised. The only thing here is it's for 2 months as opposed to 1 month at the USPTO. Once it's advertised, the application can be opposed. The grounds of opposition are a little more technical than opposition grounds at the USPTO. You can oppose an application whether or not it complies with the Trademarks Act, whether or not it's inherently registrable, whether the applicant is entitled or not, and last, whether or not the mark is distinctive. And each of those heads have corresponding sections in the Trademarks Act that are often cited in the opposition. As you can see from my slide, 90% of oppositions settle. That doesn't mean that everybody wins. Sometimes applicants abandon the mark, but it's very rare for oppositions to go to a hearing. That being said, there are a lot of oppositions, and typically the parties will enter into a cooling off period to see if a resolution can be negotiated. It's as I mentioned later, we'll expect to see more of these once our new legislation is in force. This is very straightforward. Currently, we have 15 years. Soon it'll be 10 years. As we know at the USPTO, it's a 10-year term for registration. The key difference is right now and in future, we will not require a Section 8 and 15 declaration. Once it's registered, it's set it and forget it, and nothing needs to be done. This is a question that clients and everybody wants to know. What are the typical fees for a Canadian application? Currently, the government fees are $450. There's $250 up front, and it's $250 up front, and that's a little typo. It should be $200 at the back end. The legal fees typically vary. Whenever you speak to a Canadian counsel, they'll say, well, it's always hard to say, but it's usually going to be between $1,400 and $1,600 for a total of anywhere between $1,700 to $2,000 Canadian. There is a trend right now, and I can tell you, having worked both in a very large firm and now as an independent practitioner, towards fixed fees. There's a recognition that clients need cost certainty, and they want an all-in price, and I think that many practitioners will be able to give that to you. Some like to have a look at the details first so they can sort of categorize the application of the details as being, this is going to be something that's going to be more challenging, or the system's pretty straightforward, and they want to hedge their bets that way. If you have any questions about specific fees, feel free to contact me. I'd be happy to talk to you about it outside of this webinar. Once the trademark is registered, like the USPTO, you can bring non-use and cancellation proceedings. Typically, it's 3 years after a mark has been registered. It's vulnerable to cancellation for non-use. That's the policy of the Trademarks Office, and Section 45 proceedings, which is the article in the legislation that permits this type of process, are administrative in nature and are a great way both to clear deadwood from that's blocking your application on the register, clear deadwood out, and also to strategically get to other concessions you might be looking for in some sort of dispute. Trademarks also becoming incontestable on the basis of earlier use after 5 years. The one exception being is if the registrant knew of the earlier use at the time of registration. So I've promised to discuss the changes on the horizon, and to me this is the most interesting part. The legislation, the Trademarks Act, was amended under an omnibus budget bill, and the government at the time didn't do any consultations. They worked only internally and decided unilaterally, without consulting the professional bar, about what how this would impact and how it should be implemented. And here are the key things that they came up with. The first is, and it's not mentioned on the slide, is that Canada will be joining the Madrid Protocol. For those of you who are aware, the Madrid Protocol allows you to file at your home country and then designate other nations for national entry later on. It's much less expensive for clients who want to do large-scale filings, but as you may know as well, it has its own challenges, partly because your home registration needs to survive in order for the branches in other countries to continue on. I'm not aware of many small and medium-sized enterprises in the US that are using the Madrid filing system. It has its appeal for some, but typically most people will use the conventional priority claim under the Paris Convention to enter into other markets. So Canada will be a member of the Madrid Protocol, and that process will have a box on your Madrid Protocol application process. The second part is they've changed the definition of trademark. It's gone from a more common law understanding as being something that's an indication of source to a more explicit definition of being a sign or a combination of signs used to distinguish goods or services. For me, this is the best part. It articulates what a sign can be very clearly. It can include a personal name, a design, a color, a figured element, 3D shape, a hologram, a moving image, a mode of packaging goods, a sound, a scent, a taste, a texture, and the positioning of a sign. And I think this is perhaps one of the more expansive definitions of trademark that's in play right now. And when this comes into force, I think it will really recognize the modern experience for branding and trademarks. And there's many clients who should review their portfolios to say, what are we doing that makes our brand distinctive, and how are we going to protect this from competitors? And things like a scent or a taste or a texture have always been more difficult to prove. It remains to be seen evidentiary or on the application how this will be articulated, and how you prove that the scent, the taste, or texture is distinctive. But nonetheless, the recognition of these is really going to help with non-traditional trademark protection, and also recognizing the brand equity that comes to these for our clients. As mentioned earlier, we are moving to a class system for goods and services, and it's pretty straightforward. It'll pretty well be the same. We're using the same classification system, the NICE classification NICE system that's with the USPTO, and trust me, a lot of the Canadian practitioners will be looking how things are grouped by the USPTO, and will follow the lead for many of the more technical type areas. The last, and this is to me the most interesting aspect and why this seminar is most relevant, that up until the government announced the change, it's sort of assumed by everybody who practiced trademark law that use is a cornerstone of the theory of trademarks. You have to have used a mark in order for it to exist, to have rights. And this goes back to the roots of trademark law from England, where we adopted our early legislation, and even the axiom today, where if you want to register without use in Canada, you have to have used it in another jurisdiction. So Canada is no longer going to have a use as a requirement for registration. There will be no declaration of use or registration fee for those of you who had to deal with those with prior Canadian applications. That's going to be eliminated. The consequence of this, that there's both opportunities and consequences as a result of this change. The first is it makes it easier for clients to protect their rights in Canada. The costs are likely going to be similar to where they are now based on analysis of class breakdown. But we are going to see applications covering goods and services more broad than typically would have been claimed previously, and that could create issues. And it's also going to make it more difficult for companies who are clearing their brands and looking at prospective trademarks to determine whether or not it's available for use in Canada. Previously, we could look on the register and say, okay, well, they've claimed use since August 2010, or they've been using it forever. Maybe it's not in use anymore and vulnerable to cancellation for non-use. We'll do an investigation. Under the new regime, it's going to be much more challenging to know just by looking at the register whether or not you can actually use your mark without infringing somebody else's rights, and clients are going to have to incur costs owing to investigators and whether online or on the ground research. So it's going to be a big challenge there. For those of you who have dealt with European community trademarks, where you just file and register without any claim of use, it's that type of system. It's very different from what you're experiencing in the USPTO if you've had to have battle over specimens and brought into use for goods and services. So with that being said, this is why now it's a great opportunity to get your mark or your client's marks filed in Canada to take advantage of use and registration at home and get that entitlement and priority established now. Once the new regime comes in place, which I expect will be sometime in 2018, we're going to see more opportunist trademark applications. Some people have likened it to what happens in China with trademark squatting. I don't know if it'll be as bad, but I certainly expect those speculators and prospectors to be rushing to file brands, either to get it registered or to use it as an opportunity to shake down brand owners when they come to expand to Canada. And the last point I want to make is, when you have an opportunity to review any trademarks, if somebody's talking about a new brand, just always keep Canada at the back of your mind. Given our common market and brand expansions or territorial expansions, it makes sense, and it's an easy way for you to provide some value add to your client and share some information about expanding the scope of protection in order to head off future issues that might arise down the road and in the if that's the case, as I mentioned earlier, you can look like a genius. So those are my comments. I didn't see any questions pop up. So what I'm going to do now is I think hand it over to my colleagues at Alt Legal. Before I do so, though, one of the last things I'll share with you is, as was mentioned by Hannah at the beginning, I came from a very large law firm. It was the typical BigLaw machine that had lots of infrastructure, lots of admins and supports and paralegals and everything else. And when I was establishing my own practice, I was looking for a solution to handle my portfolio, my trademarks. And the first solution I got was, how am I going to run my practice? And I'm happy to say I landed on Clio with that, but it was hand in hand with the solution of Alt Legal, because I was looking for a cost-effective way to manage my portfolio. And I met with Nahal in May at the INTA annual meeting, and we had a good discussion about this, and that's the exact time I was setting my practice, and it's been going great since then. But that being said, one of the great things about the product is I don't have to have anybody doing the docketing for me, because it's done automatically, and I love getting the emails. For those of you who are on the system, you know exactly what I'm talking about. The part of the product roadmap was an expansion into Canada, and I was very happy to hear that. And maybe now I'll turn it over to Nahal with that introduction to speak about that.
Great, thank you, John, and thank you for the very helpful content on Canadian trademark law and a very kind intro. So one of the things that we like to do at Alt Legal is really, as you've alluded to, is focus on automation. Provide automation through technology to allow lawyers to really focus on the substantive aspects of their IP practice. And we've been able to do that by directly integrating with IP Office databases where that's possible to provide a more modern docketing solution, and providing robust rule sets for IP offices where we don't always have the data readily available. And in addition, we've also integrated with a product line like practice management solutions like Clio to provide the other back-end functions necessary to run a in-house legal department or a law firm that's handling intellectual property work. So what you're seeing on our screen is our docketing system. And let me just activate our screen share here. And this is what our docketing system looks like, where you log in as an IP attorney, and what you're most concerned about if you're an IP professional are your deadlines. And that's instantly what you see. Every single trademark that you have, every single patent, copyright, dispute, and the deadlines that you have associated with it, what you have to do and when you have to do it. And all of this information, particularly with the USPTO, is automatically retrieved. Every document is available to you with a click. So one click and you'll have that office action downloaded. Everything is at your fingertips, essentially eliminating a lot of need that you traditionally had to have someone full-time dedicated solely to docketing, which is mainly how these larger law firms have operated in the past, and how legacy docketing systems operate. One click, you'll have information about the trademark filing itself. And yet under a click away, you'll be able to generate letters and inform your clients or colleagues in-house about the status of their IP filings. And particularly with respect to Canada, what we've done is provide a complete rule set where you'll be able to update the information about the record and instantly have the appropriate deadline calculated. So for example, this particular trademark, Clio's trademark, will automatically calculate the renewal date as soon as you provide the information that has been registered. And then Canada's, John mentioned, 15-year deadline here to renew, which is automatically calculated. And one of the other unique aspects of our software is that we do integrate with Clio, and we have both Joshua and Colin from Clio in the webinar to answer questions here. And the way we do integrate with Clio is we take your core docketing deadlines and automatically put them into a Clio calendar for you. We also link all of your contacts between Clio and Alt Legal, and we also provide you with the ability to link matters with your account in Clio. So truly, all of the information that you need to manage your docket or any particular trademark filing is available on one page, rather than you having to double docket or manage two different systems. And so as an example here, within Clio's product, when you log into your account, you'll see complete dashboard, everything that you have to do, of course, and within your calendar, you will see your key docketing events all right here that are automatically transferred from Alt Legal into your Clio account without any manual data entry. It'll do this for each of your deadlines, and it'll do it once a day. But more importantly, all of your matters that are in Clio are transferred to Alt Legal and vice versa. And all of your contacts that are in Clio are transferred into Alt Legal. So you can always have both information, all the information in one place. And so really what we've tried to provide is a complete solution between Alt Legal and Clio, so you're able to manage your practice and focus more on the substantive aspects. And particularly, I think as John mentioned, coming from a larger law firm where you may not always have the resources of a smaller organization. And with that, if there's, take a quick moment for any questions for either Alt Legal's team or Josh or Colin from Clio. Great. Well, I want to thank everyone for attending today. We'll be distributing all of the slides, all of the content, as well as the recording from the webinar. And if you have any questions, you're welcome to contact us at support@altlegal.com. And if Clio's team could provide the best form of contact for them, we'll happily provide those follow-ups. And John can be contacted at john@leeipt.com. So that's john@leeipt.com. And of course, we'll be including this when we send this out. And Clio can be reached at support@clio.com. Great. Thanks again, everyone. And you're also welcome to call Clio at 888-858-2546, extension 2. Thanks again.